Thank you, Chair. Mr. Nciza, just to confirm, you're still in possession of your 2 files?
Yes, Council.
Thank you. We were at paragraph 48 of your witness statement on page 18. Paragraph 48.
Yes.
Indeed. Just before the lunch break, you gave testimony about a telephone conversation between you and the city manager, Dr. Mashazi, where she told you in no uncertain terms, "Limutlokhele Julius," and directed you to facilitate his return to the office.
Yes, ma'am.
Thank you. In light of that evidence, I wanted to pose a few questions to you, particularly in light of our discussion this morning concerning the collective agreement. In terms of the collective agreement, Mr. Nciza, which official in the city has the power to suspend and extend suspensions of employees?
Thank you. Commissioners, like I indicated yesterday, how the system works is that the municipal manager has got the overall authority, but then the municipal manager has appointed an authorized representative. So the authorized representative would then be seized with the process of suspensions, will be the head of department HR, Ms. Linda Kashega. So as much as the municipal manager has overall authority, the person seized with the process would have been Linda Kashega.
And so in circumstances where Ms. Kashega was seized with that authority, on what basis did the city manager act when she intervened and instructed you to facilitate the return of duty of Brigadier Mkhwanazi?
It's a tricky one because in the absence of a submission by the municipal manager that goes to the merits of the suspension, because the municipal manager has a right to say that, but the merits of this suspension are poor, and therefore I do not agree that this person should be suspended. So on the basis of that, where there is a rational disposition that exists for the municipal manager to intervene based on the merits of the case, then indeed one would say that the municipal manager then would be within her rights to then intervene and stop a suspension. But that was not the case in this instance. You know, as Madam Commissioner had previously asked whether indeed there was a discussion on the merits, there was none. So that disposition then would not apply in this instance, where we would expect that a municipal manager would deem it fit to intervene.
So when the municipal manager says "Limotlokhele Julius," did you understand that to relate only to the suspension or the entire process? In other words, the investigation and the initiation of the disciplinary process and the appointment of the panel, as you said. What did you understand that to mean, Limotlokhele Julius?
At that point in the discussion, this is before, of course, other processes that would then follow subsequent to this discussion. The discussion was narrow in the sense that it was about Julius coming back to work. There shall be no extension of the suspension, you know. So in a narrow sense, one just took it that this is about the suspension. And therefore, let me just leave it at that. There was no specific instruction issued regarding the disciplinary case itself.
The reason I'm asking you this is if you go 6 paragraphs back in paragraph 42, you say, after the discussion amongst ourselves, I made a decision to constitute a disciplinary tribunal.
Yes.
Now, let's go back to my question. So it's not just the suspension, it's also the constitution of a tribunal and other things. Now, when she said to you, Lemotlogele Julius, did you understand that to mean don't extend the suspension, but continue with the constitution of the tribunal and other things?
I understood it to mean don't extend the suspension. You know, remember, I have never discussed with the city manager the issue of the constitution of the disciplinary tribunal. You know, even during the course of this conversation, there was no engagement about the disciplinary tribunal at all. And like I indicated, this was like she came down at me regarding the suspension. There was really no angle or even an opportunity to engage to say, but there is this other aspect. That was not her concern. Her concern was Julius must come back to work, so to speak.
Thank you, Commissioner. Mr.
Sorry, in the absence of what you've described as a rational explanation for why the instruction, the Lemotlogele Julius says she wants her back at work tomorrow, is it not, if you spoke frankly and freely, is it fair to describe it as a simple abuse of authority and power?
It was not a simple abuse of authority and power.
No, what I'm saying is...
This was abuse of authority and power in the extreme.
Okay, yes. Thank you.
You know, especially where there is not even an engagement on the merits. Why the extension? There's no... If the conversation had gone along the way of saying, I understand that you intend to extend this suspension. Can you give me the basis of that? See, then you would say that there is a rational engagement. You know, now that you've given your superior, your boss, the basis, the boss says, no, that's not sufficient for you to actually do this. Then if it had flown that way, one would say, you know what, the municipal manager acted in accordance with what we'd expect of a chief executive officer. But in this instance, it was not.
Thank you, Commissioner. Mr. Nciza, please then go to paragraph 49 and detail those events to the Commission. Paragraph 49.
Now, you can imagine after the call was dropped, my first instinct was to get hold of the head of department. I remember I'd been in this journey with Chief Mapia since he came back from leave in February. And there'd been numerous engagements between us regarding this particular matter. So the first instinct was to get hold of him and to relay that, hey, Munna, I've just received this call. Unfortunately, I could not get hold of him. His line was busy. But then eventually he called me back and relayed that, hey, Munna, I've just received this call. Instead of me relaying to him that I've received this call, he started off and went at me to say, hey, Umama has called me. And this is what she's telling me, that Julius must be back at work tomorrow. Of course, he was displeased. And then I indicated to him that I also received a similar call. And in sharing our notes over the call, exactly the same thing happened to him as it had happened to me. The basis of the instruction is that we are personal, we hate Julius, there is nothing wrong with Julius, he must come back to work in Tosaru.
Please then continue to paragraph 50.
And given the fact that indeed the person that must make the determination to extend or not is Asheka, I tried to get hold of her. And unfortunately, I could not. And I mean, this is now around about 8 or past 8 at night. I could not get hold of her that night. However, the next morning, when I checked my phone, I discovered that Ms. Xolani had responded to me at around 10 to 1 in the morning.
Mr. Nciza, perhaps I may assist you. If you turn to page 289 of the annexure bundle, your 289, that is annexure PN7.
Thank you,
Perhaps
Council.
you can give that evidence with reference to the page.
Thank you, Council. On page 289, indeed, on the 24th of May 2023, recalling commissioners that my engagements with the city manager were the previous night, just before 7 p.m. And I tried to get hold of Ms. Xolani, and I couldn't. Then she sent 2 messages to me. The first one at 0049, so sorry, I had a load shedding, electricity just came back now. And then at 0050, she said, please draft a letter for Julius Mkhwanazi is resuming duties today. I hope Chief contacted him.
And you then responded to say?
Because I had received these messages, I saw them in the morning when I woke up. At 6:32, I greeted her, good morning, HOD. And then I said, I spoke to Chief, the letter will be ready when we meet. And then in response to, of course, to a load shedding message, I said, unending crisis, like everybody was experiencing load shedding.
Thank you.
Is that if you know that this is wrong and Chief knows that this is wrong and the HOD knows that this is wrong, why do you go along with it? Is there no grievance procedure within Ekurhuleni municipality that allows you to say the municipal manager is unlawfully interfering in a process? We want to report this thing.
Okay.
Are you not making the situation worse? I mean, you know what the allegations are. You saw how serious they are. There was a report of somebody being murdered. Knowing all of that, the 3 of you just agreed to draft a letter. He will come back to work. We will move on with our lives. I don't get that.
Yeah. Perhaps let's try and respond like this, Commissioner. I received the call that gave the instruction. I don't agree with the instruction, but nonetheless, it's the instruction of the Chief Accounting Officer. My first point of call is to talk to the department. The department has received the same instruction. We are both unhappy. But recall now, the person who actually has the authority to extend or not extend is Xolani, not us. At the end of the day, Xolani is the one that must make the determination whether to extend or not to extend. We try to get hold of Xolani. I don't get hold of her. But when I wake up, I find that Xolani has already issued the instruction that he must come back. So the sense that I had is that clearly Xolani would have engaged with Mashaz. Maybe after the 2 calls to me and Mapie, Mashaz would have called her. The engagement would have happened between the 2 of them. Then Xolani issues the instruction for me to draft a letter for Mkhwanazi to come back. Now, even if I was to submit a grievance, the only type of grievance that I can submit in terms of the grievance procedure in this instance would be a grievance to the executive mayor. Now, I'm not the one that actually would be submitting such a grievance because I'm not the one who must actually make the determination on whether there is an extension or not. The person that must make the determination if she has agreed, and I'm not privy to the actual discussion that happened between Xolani and Mashaz. But Xolani instructs me to say, draft a letter for Mkhwanazi to resume work. Mine is to then draft that letter. I agree with you that indeed it was wrong. It was wrong in terms of the instruction itself was wrong because it did not have a rational basis. But at the end of the day, the person that was supposed to stand up and say, no, it's my authority. You are now usurping my authority, and therefore I will not do that. I have been briefed by my divisional head. I've been briefed, or rather the department had motivated, and my divisional head has briefed me, and I have agreed with the extension, and therefore I stand by my decision to extend. That was the duty of the HOD HR, who is seized with the power to extend.
What did she say is the reason to do a letter for that instruction to you? Did she explain anything to you?
When we met in the morning, because I went directly, instead of going to my office, I went directly to Germiston in the morning as I was instructed to facilitate. So I would not have facilitated this process from Benoni. I went to Germiston and I engaged Ms. Lashega on the content of the conversation that I had with Mashazi the previous night. And she also indicated that she also received the same call. Now, what I'm going to say to you might be a bit of a shocker, but it was the norm. It was our experience. Xolani undingxolisile lo mama. Andifuni ukuthi uMashazi mina yenza le letter. Xolani, this lady has shouted at me. I don't want to be further shouted at. Do the letter. I'm saying it was a norm because every instance where something has to happen in the municipality and HR must do something, if you have an issue, you will be told that I don't want to be shouted at by Mashaz.
All right, thank you.
Thank you, Commissioner. Mr. Nciza, you are then at paragraph 51 of your witness statement, where you make certain remarks or conclusions on this intervention. Can I invite you to share those with the Commission, please?
Yes. I make this remark here, Commissioners, because this was not the first time that we have a situation where there's an extension of a suspension, and it certainly was not the last. There is a gentleman that we had suspended who was at a divisional head level. That person was suspended in May 2023. An investigation of sorts was being conducted in the department. At the end of the suspension period in August 2023, Klasheka instructed that a letter be composed to extend the suspension. And we've got a number of other instances where suspensions in the municipality would be extended, either because the investigation is still underway, or at times the disciplinary proceedings have commenced but have not been concluded, and then a view is taken that indeed the suspensions be extended. So the manner in which this was handled was out of kilter with how others were handled.
And so you're saying in that example in paragraph 51 that even in the context of a suspended employee where the allegations against him were at that stage still preliminary, an extension of the suspension was granted and the employee was directed to continue staying away from the office?
Yes.
Yes. Viewed as against the case of Brigadier Mkhwanazi, where the formal internal investigation was completed and a docket was already submitted to your office, and yet the extension of the suspension was not granted.
Was not granted.
Thank you.
And remember, the point of the matter is the non-extension, so to speak, had nothing to do with the actual facts of the case.
Can I then allow you to conclude on this subject with what is stated at paragraph 52, my apologies.
Yeah, I don't know whether I'm allowed to just correct the statement.
You're welcome, please.
Yeah, I think commissioners, I think my use of the word endangered witnesses is a bit strong, and I would not be in a position to actually support that. But I would rather say that this intervention potentially compromised witnesses. Because that is one of the key issues that you don't want to see happening with regards to a discipline management process, that your witnesses get compromised as a result of the active presence of the accused employee in the institution. So this potentially compromised witnesses of the municipality, the documents that would have relied upon at the hearing, and even the integrity of the disciplinary process itself.
Those were the very reasons that you put for suspension.
For the suspension in the very first place. In my view, those reasons still existed. Not only my view, but also the view of the department. Those very reasons still existed at that point.
Yes.
And would you then agree, Mr. Nciza, that the very risk you were attempting to prevent, the risks identified in paragraph 52, the efforts to prevent them through the use of the suspension were undermined by the upliftment of the suspension?
Yes, ma'am.
Thank you. Thank you. Can I then ask you to turn to paragraph 53 and detail the events of the 24th of May? Paragraph 53.
So after I had met with Ms. Lasheka at the office, and we had agreed that indeed we will do the resumption of duty letter. I mean, to do such letters, there's a template, so you would just craft it, say it's a quick thing. I had to leave her office and go to what is called the administrative precinct. The office would be, if it's on this side, the administrative precinct would be where council is sitting, and then the government precinct would be where you are sitting as commissioners. So her office is this side, left, then straight. So I had to go to the administrative precinct, where the city manager's office is located. There is a huge parking lot in between. There are two parking lots actually. So as I was walking towards the administrative precinct, I ran into Brigadier Mkhwanazi in full uniform, at the parking lot. We greeted each other, and then he indicated, as per what is on paragraph 54, tried to engage me to say, no, Xolani, these guys signed documents that they are now accusing me of, so like, no, these guys have signed, but they want to fire me for what they've already signed. So I avoided the engagement. I was like, okay, yeah, hey, nah, into Zakon. I didn't want to engage. Remember, I was aware of what is contained in the investigation report. And as a matter of principle, I do not engage with employees that are the subject of either a disciplinary hearing or investigation on the contents of that particular process. So I was like, no, just downplayed it. And he was on his way to see Lasheka at the time. And I just politely sort of disconnected and went on my way. And I didn't want to engage him on the substance of the matter.
Please proceed to paragraph 55.
Now you have a situation on the 24th where Mkhwanazi is back. I engaged the chief of police to say, okay, fine, now what? what is the plan in your department in terms of how do you handle this situation? He indicated that, no, it's fine, he's back, but I've redeployed him. I don't want him in the unit where all of these things were happening. I've redeployed him into bylaw enforcement because that position was vacant at the time. And of course, the basis upon which he wanted to redeploy talks to what I have raised even on paragraph 52, ensuring the integrity of the disciplinary process, is kept. So that was his concern. And I later learned, not on the 24th of May, but sometime in June, that another intervention had come about to direct that Mkhwanazi go back to his substantive position of Director Specialized Services.
Thank you. And therefore that the efforts of Chief Mapie then to try and keep Brigadier Mkhwanazi outside of his original station were unsuccessful.
Yeah, they were unsuccessful, because at the end of the day, the municipal manager, gets involved. She gets involved, even though the letter itself that actually directed that Mkhwanazi must go back was from Tlashega. You ask yourself even how does Tlashega get to know that Mkhwanazi is deployed to another unit instead of his former station? So there was just this pressure that was put on Chief PA that, you are going to do this thing our way and not the municipality's way.
Mr. Nciza, with reference to paragraph 56, at some point in May of 2023, it becomes clear to you that the imminent arrests are not so imminent. Please then tell the Commission what steps you took thereafter.
Now, this is after the 24th of May. I engaged with the chief, I engaged with Peace and Erasmus, and the view is then taken because for me, my processes still need to run. I have no instruction from anyone that says the process that I've approved in April should not run. So I then engage them, and the view is taken that I must now constitute the disciplinary tribunal. My 3 months is running short. We are already left with less than 1.5 months. So we then took that view that indeed I must now process what you call the disciplinary tribunal, let alone the issues of the suspension, because the suspension, was dealt with. It is for me, honestly, it was a closed chapter. I was not going to concern myself with the suspension. I need to deal with the disciplinary tribunal at this point.
And if I take you back to paragraph 56, in addition to your concern that IPID was not going to arrest anyone anytime soon, you detail there a further concern that you had about the dynamic in the work environment, I would say.
Yes.
Please.
I mean, it was clear. It was clear how the matter of the suspension was handled, that Mkhwanazi has been protected by Tlashega and Mashazi at that point. It was clear to me that, in respect of how the suspension was handled, that was the situation. But I still needed to ensure that my process is carried through.
To your knowledge, Mr. Nciza, did the city manager and or Ms. Tlashega become aware of the IPID investigations? Were they, as far as you know, did they become aware of that at the time that you were given the instruction to withdraw the suspension? or not to extend the suspension?
The IPD investigations.
Yeah.
My understanding at the time is that Chief Mapia had informed the city manager that there was an IPD investigation into Mr. Mkonazi's activities. But the extent of that at this point, because you see, there's a lot that happens post-May. At this point, the extent of her knowledge, I would not be able to say at this time in May.
Thank you.
Thank you, Commissioner. Mr. Nciza, we're then at paragraph 57, where you've explained to the Commission your decision to move ahead with constituting the disciplinary tribunal. With reference to that, your second sentence in paragraph 57, please just explain what factors motivated the appointment of external lawyers there.
As I had indicated, in terms of how the collective agreement is structured on the default position. Now, when I look at the default position of appointing a person to preside that is a level or 2 levels higher than the position, it meant that I would have to appoint a divisional head or an HOD. Now, there were very few divisional heads and even less HODs that were trained to be presiding officers or even prosecutors. So already we've got a very limited scope, Secondly, experience has proven that in that very limited scope, people are very busy. They simply do not have time. And that had been reported to the municipality on numerous occasions, that it would always be a challenge to get a divisional head to reserve time and not deal, for instance, one of the people that would have been appropriate for the appointment would be a divisional head in the water services department. And you're having all these challenges with water services, and then you expect this guy to go and sit in a disciplinary hearing for a week. It's just impossible in the municipality. That is a consideration that talks to the complexity of the situation, but also the complexity of the situation in terms of the merits of the case. Where such that when we are dealing with matters or charges that would involve issues of gross dishonesty, a person that would have to sit at such a hearing must have an acute understanding of the policy regime that governs these processes, that were involved here. And then also not only the policy regime, but also these legislative issues that will come into play when we are discussing, or rather when we are busy prosecuting a case of this particular nature. So those complexities play a fundamental role in terms of a determination that must be made on who to appoint within the limited scope. So then it became clear to us that we would have to get external legal services for us to be able to deal with this matter. As well as, of course, the potential, given the totality of what was at our disposal in terms of the information on issues that Brigadier Mkonazi was implicated in, besides just the blue light scandal. That will be a nice one. So besides the blue light scandal, you then have to look at...
Maybe it's there somewhere.
No. So you'll also have to look at... It's only responsible for a person who's head of a labor relations environment where you've got more than 20,000 employees to make decisions that would not only benefit your process, but also benefit those that are connected to your process. The potential for victimization or even harassment of the very same people that will be the disciplinary procedure, disciplinary tribunal committee. There is that potential that we must look into. And given what we had in terms of the activities of this individual and those that are connected to him, it would not have been a rational decision for me to insist on having internal people dealing with this matter, quite honestly. Hence, we then took a view to appoint the external legal representatives.
Thank you. Mr. Nciza, can I ask you to turn to page 290 of your annexure bundle?
Yes.
There.
I'm there.
Thank you. You set out in paragraph 58.1 one of the appointments that you made.
Yes.
Yes. So can I ask you to take the commission through that paragraph with reference to this document?
Yeah, I appointed Madlanga Attorneys, which is a firm of attorneys that is on the panel of attorneys of the municipality. And in the appointment, I mandated them to brief Advocate Sandile Sibisi to prosecute Brigadier Mukhanazi.
Is it necessary to mention the names? Is it not sufficient to just say a firm of attorneys and counsel?
Fair enough. We can do that, Commissioner. Mr. Nciza, in the course of giving evidence as it relates to the two appointments that you made, are you able to do that without direct reference to the individuals involved?
Sure.
Thank you so much.
So I appointed a firm of attorneys that is in the panel, and I requested them to brief an advocate, I think he's in the Johannesburg bar, to prosecute the matter and to prepare the charge sheet.
Can I then ask you to go to Annexure P in 9, which is on page 291 of your annexure bundle? Okay. And
similarly, in line with the determinations that were made in respect of the appointment of the prosecution team, I then appointed a firm of attorneys that is also on the panel of attorneys of the municipality, and I requested them to brief an advocate who would then be the presiding officer in the Dismary Tribunal.
And having constituted your tribunal now through these two appointments, please explain from paragraph 59 the subsequent developments following those appointments.
Just as a matter of note, commissioners, in both appointment letters, you will note that there is a line that says, please note that the internal official responsible to this matter is Mr. Nciza, with the landline telephone number in both instances. So then ordinarily, a matter would be allocated to a labor relations officer or a labor relations manager. But in this instance, like I had said initially, I wanted the matter to reside with me in my office. So I then communicated with the firm of attorneys and directed them to say that this is a matter that is in the EMPD, and therefore they would need to be in consultation with the EMPD in order for them to get, as much as there is a docket, but also to get witnesses that will be in a position to testify on the matters that were contained in the docket, and which would also assist them in the process of drafting the charge sheet. So yes, I indicated that. And then I don't know whether I should just continue with how the entire process.
Please proceed. I'll ask Mr. Nciza that when you give the identities of the individuals involved in preparing the charge sheet, you'll omit the names of those engaged by the law firm. Thank you.
So indeed, there were numerous individuals from the department who then got involved with the preparation of the charge sheet. Of course, given the nature of the allegations, the process itself became a bit more detailed than what one had initially anticipated. You know, there were several engagements that were held, and I was involved. Persons from the firm of attorneys were involved, and then the investigator that compiled the investigation report, which is Erasmus, and then I involved at this stage. It's when I then decided that I would also need to involve the manager in my office that deals with discipline processes, because now it is at a stage where the actual facilitation of the disciplinary tribunal must take place. And in most cases, I would not have sufficient time to be involved directly with the actual disciplinary hearing. Yeah.
Yes, please proceed to paragraph 61.
The charge sheet was at a later stage amended in order to include additional charges. This would have been around about the 19th of June, when there was an indication, 19th, 20th June, when there was an indication that indeed the charge sheet did not include matters that pertained to the operational plan. And therefore the charge sheet was then amended, and eventually the final charge sheet was supplied by the firm of attorneys on the 20th of June 2023.
And that charge sheet is annexure PN10, which is found on page 292 of your annexure bundle.
Yes, ma'am, it is.
With reference then to the charge sheet, Mr. Nciza, you've indicated that it contained 6 charges.
Yes, ma'am.
Correct. The heading at the top of page 293. Could you please read that text highlighted in bold at the top of page 293?
Charges: failure to conduct yourself honestly and thereby infringing the disciplinary procedure collective agreement.
And you confirm that's the document we went through this morning?
Yes.
The DPCA, thank you.
Yeah.
Mr. Nciza, I won't ask you to read the entirety of the charges into the record. We've attached them for the attention. My apologies. Okay. I won't ask you to read the entirety of the charges into the record. We've attached them for the convenience of the commission, for the benefit of the commission. What I will ask you to do is to take the commission through, sort of a summary of a charge as it's set out there.
Thank you, Council. Commissioners, the charges that are set out relate first and foremost to the memorandum that we dealt with of the 16th of October 2021 that spoke about EMPD being under the command of the brigadier and all the endless working relationship, where indeed we were alleging that even the crafting of that particular memorandum amounts to gross dishonesty on the part of the brigadier. And then you have the charge number 2 basically speaks to the issue of the memoranda of agreement, the 2 memoranda of agreement between purportedly between the EMPD and CAT security services, as well as Medicare 24 emergency services. Again, the issue here is about gross dishonesty, because the allegation is that the brigadier had made it seem as if there is indeed a memorandum of agreement that was entered into between the parties. And he placed reliance on that order that caused other people to place reliance on that submission. And then number 3 effectively deals with the registration of the 4 vehicles onto the municipality's name, which will be dealt with in terms of the processes that he engaged with Christine and them, and got those vehicles registered under the municipality. And again, the allegation is that this amounts to gross dishonesty and abuse of the resources of the municipality, as well as his position of authority. The 4th charge is about the implications of that memorandum that was issued. That effectively means that people can impersonate police officers, because they would have a memorandum on the letterhead of the municipality that states that these people are having this working relationship with the municipality, and therefore, as people that are working with the municipality on these specific issues, those people can then be taken to be members of the Metropolis Department, and indeed, by extension, those people can then be taken to be allowed to use blue lights because of the impersonation of a law enforcement official. Again, the allegation is that indeed this amounted to abuse of his position and gross dishonesty, and as well as abuse of the resources of the municipality. And then the 5th charge relates to the issue of the donation in terms of the report that he had submitted to Commissioner Spies. In the report that he had submitted, he speaks to, I think it's the report that contains the titled cartels. That report, he speaks to a donation that he had solicited and received to the value of 300,000 rands. So this, again, is about the non-observance of your council processes, your council policy and the likes. Again, this amounted to gross dishonesty, abuse of the resources, insubordination, and abuse of the position of authority. And then the last charge is the one that is now talking to the operational plan. And the argument here is that the operational plan that was submitted by Brigadier Mkhwanazi in February 2023 pertaining to the state of the city address, was altered and therefore constituted a fraudulent document that he had submitted.
2022.
2022. Yes, state of the city of 2022. Thank you, sir.
Thank you.
Yeah. So those, in essence, were the charges. The 6 charges.
Thank you. And Mr. Nciza, if I might just turn your attention, for example, to charge 6 on page 294. The last sentence there reads, your conduct amounted to a violation of clauses 1.1, 1.2.3, 1.2.4, and 1.2.5 of the DPCA.
Yes.
Do you have, are you able to give the Commission a sense of what those clauses in the DPCA relate to?
Yes, Commissioners, the DPCA, which is, I don't know what is it marked as.
15
15.
B, 15B.
Right at the end of the DPCA, I think if you look at the numbers, at the bottom where there's initials, page 24, the DPCA has got an annexure. After the collective agreement has outlined all the procedures, then it has an annexure.
Just to assist you, Mr. Nciza, so we're all on the same page, you've directed us then to 15B, that's
Yes.
Circular 1 of 2018, the DPCA. You've asked the Commission to turn to Annexure A on page 24. Is that right?
Yes.
Thank you.
Exactly.
Please continue.
So whenever you draft a charge sheet, and this commissioners have experienced not only in Ekurhuleni, but in other municipalities where I've been called upon to assist with discipline management, you have to, in the charge, having outlined what is the charge, then a prosecutor would ordinarily put which clauses of the standard of conduct the employee has violated. And in labor relations nomenclature, this would be what rule has been broken. So the first one, and we'll see that in almost all the charges, there is a consistency, 1.1, that there's an expectation to comply in every respect with the conditions of employment and collective agreements and any related regulation, policy and practice of the municipality, and to refrain from any conduct which would give just cause for discipline. So that is a standard that the prosecutors had put, that what Brigadier Mkhwanazi had done give rise to a just cause for discipline. And then 1.2.3, perform their tasks and job responsibilities diligently, carefully, and to the best of their ability. So effectively, the charge also talks to that. All these charges say in what the brigadier had done, there was no adherence to a diligent performance of one's tasks. 1.2.4, obey all lawful and reasonable instructions given by a person having the authority to do so. Clearly, if a person is going to go and do things that are outside the policy framework, that is a person who's not obeying instructions. 1.2.5, conduct themselves with honesty and integrity. So that is what effectively the prosecutor had crafted as a case of the municipality against Brigadier Mkhwanazi, that his actions are in contravention of the disciplinary procedure collective agreement in relation to that standard of conduct.
And Mr. Nciza, if we stay in Annexure PN10, which is the charge sheet, if we turn to the last page of the annexure.
Sorry, before we go to PN10, the documents you have marked 15A and 15B, should they go into Annexure PN4? Where exactly are they supposed to go in our bundles?
Under Annexure 15, Commissioner.
PN15?
Correct.
Oh.
Correct.
Yes, ma'am.
On page 296, Mr.
96.
Nciza, that is the last page of Brigadier Mkhwanazi's charge sheet. There's a paragraph there drawing attention to the engagement of a prosecutor to initiate the proceedings. Do you see that?
Yes, ma'am.
Thank you. At the bottom of the page, bottom right corner,
Yes.
where it says confirm receipt,
Yes, ma'am.
what purpose or what utility does that section of the charge sheet serve? What is ordinarily meant to be recorded there?
When you serve an employee with a charge, you need to certify that indeed this person has been served. And the best way to certify that the person has been served is for the person to acknowledge your receipt of the charge sheet. So what would happen is when you serve, you would have two documents. You would have the charge sheet and a copy. Then you'll give the employee, and then the employee must sign on the copy that indeed I have received this charge sheet. So that even when you go to the actual disciplinary hearing, the presiding officer can satisfy himself that there's proof of service on the employee. That is the standard.
And was there in fact proof of service on the employee? Was this charge sheet served?
No, the charge sheet was not served.
No. Can I then invite you to paragraph 63 of your witness statement?
So on the 20th of June, Commissioners, the final charge sheet that all the parties involved were satisfied with, and I'm saying all the parties involved, critically for me, the case in a disciplinary inquiry must be made out by the department. So it's important for me that the department is satisfied with the charge sheet, because it is the department who are the witnesses, it's the department who are the experts on the policies, on the procedures that must be followed in the department. So when I say the parties, critically, it is the department that had also confirmed that indeed they were satisfied with the charge sheet. Then I instructed Mr. Zitsamba. I instructed my manager to then process the serving of the charge sheet as per the norm in my office. So the manager then came back. I think the final charge sheet was emailed to my office. It was just before 1. It was just before 1. Then he had called, or that he came back to me and reported that he had called Brigadier Mkwanazi and indicated that he wants to make arrangements for the service of the charge sheet on him. However, Brigadier Mkwanazi had informed him that he is not going to come. He's not going to meet with him, and he's not going to accept the charge sheet. And the reason why he was not going to do that was because he, Brigadier Mkwanazi, had instructions from Dr. Mashazi, the city manager, as well as Ms. Kashega, the HODHR, not to accept the charge sheet because that case is not going to fly. Not only did the manager indicate that conversation with Brigadier Mkwanazi, but there was a further conversation that he had had immediately after having spoken to Brigadier Mkwanazi. Indicates that he was then called by the personal assistant of Ms. Kashega, who informed him that Ms. Kashega has instructed that he must not even attempt to serve that charge sheet on Brigadier Mkwanazi. So that's why the charge sheet was not
never
served.
served. And Mr. Nciza, in your engagements with the HR manager responsible for the service of the charge sheet, did he ever relate to you the basis for that intervention? So on what authority or on what basis did the city manager and Ms. Kwashega direct that the charge sheet should not be served, or that the brigadier should not collect the charge sheet?
Well, he did not have a basis. He did not relay a basis because he just indicated that he was instructed not to serve, and there was no reason provided to him. Instead, he was miffed. He was like, but what is this now? Since when are these individuals part of our process? This is an ER process. You have appointed a disciplinary tribunal. Now all of a sudden you get calls that we must not do our work.
And what did you say to him in response to that? So after he updated you about his challenges with serving the charge sheet, what was your response to him?
Given my experience the previous month regarding the non-extension of the suspension, I had a sense that something is afoot here. So I requested him to just simply record in an email what has happened and to inform the prosecutor.
And all of this happened without Mr. Sheka speaking with you? Did she not speak to you at all?
No one spoke to me. No call from Mr. Sheka, no engagements with the city manager.
Yes.
This was just relayed to my subordinate.
Thank you. Thank you.
Thank you.
Maybe you compared estimates and costs.
Incurred costs employing 2 advocates and a firm of attorneys to prepare the charge sheet and to act as a prosecutor and a chairperson of the disciplinary.
Yes, Commissioner, I will get to the costs factor because indeed costs were incurred, but not for the presiding officer. The presiding officer, as much as an instruction was issued, there is no work that the presiding officer has done. The people that would have done work is the prosecution team to prepare the charge sheet and the likes, and the consultations that they had with the potential witnesses of the municipality.
So all that money was wasted for nothing.
Effectively, this meant that the money becomes wasted. And there's going to be a discussion about that particular aspect. But I want to indicate that indeed the money became a wasted money because of the intervention.
And your policies and procedures, including the collective agreement, do they give the HOD of Human Resources the power or standing to give this kind of instruction?
No, not at all. Like I explained the delegations matrix before, the only person that was delegated in the municipality as of that time to institute disciplinary tribunals is the divisional head employee relations, no one else. The municipal manager would only institute a disciplinary tribunal in respect of a council resolution to discipline an HOD. And that is as per the disciplinary regulations for senior managers. The regulations stipulate that if council has taken a view that there must be disciplinary process, then the municipal manager, by way of council resolution, must appoint. But in respect of everybody else, especially people that are governed by the DPCA, the delegation resided with the divisional head employee relations and no one else.
Thank you.
Thank you, Commissioner. Mr. Nciza, you make some remarks in paragraph 67 of your witness statement. Can I ask you to briefly share those with the Commission?
This Commissioners, is in line with my response that I've just given now to Commissioner Baloyi. And this is borne out by a process that the municipality went through, a very painstaking process that the municipality went through between, I think it started around 2016, that case, until around about 2022. This LAC judgment that I speak to here, where again, unfortunately, it's in the EMPD. It seemed that this was a problem child department. It's in the EMPD when there was an attempt by the then acting HOD-HR. There was an acting HOD-HR in a recruitment process where there is a policy framework, and the policy framework provided that if you are going to do some form of exceptional circumstances recruitment, I'll say exceptional circumstances recruitment because there need to be a deviation from your recruitment and selection policy. That policy then gave the authority to have those exceptional circumstances processes to be done by the divisional head workplace, it was called workforce capacity management. And that divisional head had that authority, no one else. The policy is clear. Now, in this case, we had a situation wherein the acting HOD-HR intervened and processed an exceptional circumstances recruitment process. The matter went on. Unfortunately, it was just before the elections in 2016, and then a new, administration came in, but then Dr. Mashaz was the acting city manager. She became the acting city manager, and she did not approve the appointment of the person. We litigated that matter, went to arbitration. The arbitrator said, but if the municipal manager and the HOD-HR have taken a decision, the DH's authority stems from the city manager and the HOD-HR. Therefore, he surmised that it is proper. If these ones have taken the decision, they've effectively overruled the DH. We went on review. The Labour Court agreed with the commissioner that it was a reasonable award. We went to the LAC. The LAC said, no, it's not. The principle of legality vitiates that thinking because you have a policy position that says this person and no one else is delegated to do this function. So you can't have another functionary in the municipality taking over that function. So from that perspective, even though the HOD-HR was my supervisor, the function, the authority to do the function resided in the DH position. So the supervisor then does not have the authority to override the decision of the divisional head.
Did you show them the judgment, Mr. Nciza?
They have it. I mean, we
You know, I'm talking about at the time when they intervened in June 2023.
No, I did. Quite honestly,
Because your point is that they had no power to do what they did, and you're relying on this judgment. So I'm saying, if that was your position at the time, why did you not say you don't have the power to intervene or to interfere? And here is a judgment that tells you that.
yeah, Mr. Commissioner, sometimes you have to read the room. Honestly, you have to read the room. We were confronted here by things that were unheard of in my entire career in the municipality. Even the example that I gave earlier on about intervention by the municipal manager in 2017, it was not at this level. It was at the level where there was no disciplinary tribunal constituted. It was just a report from the department, and she stopped it even at that level and then instructed me to do a new directive on how these things must be handled. This one was just unique. This was unique. And the situation that we were faced with, quite honestly, we were not going to go up against Mashas. Heads of departments.
I think people who abuse power are enabled by people below them who act defeated, and they just say, oh, well, I've read the room, it looks like, I know this is unlawful, but I'm going to go along because what can I do?
In a way, you are correct. I believe also in that principle that in order for evil to prevail, it only takes good men to sit and do nothing. I believe in that principle. The system in the institution is such that if indeed you have that view, you have to then either submit a grievance to the mayor, and I can tell you now, grievances that are submitted to politicians honestly go nowhere. Or alternatively, I think it's section 64. Again, section 64 talks about appeals, but they are mostly meant for your residents if they've got issues with regards to municipal decisions. Now, even if you were to do that, again, it goes back to submission to the mayor, and the system, it's especially at municipal manager level. Yeah, I agree with you on the principle, but at municipal manager level, it's not that easy.
Is it a function? Maybe I may ask, what is it a function of? Is it that there are no, that there isn't enough safeguards in the system that, and as a result, the kind of conduct that you're complaining about, including at city manager level, it has a fertile environment to function successfully? And what should be done? What is it that is missing in the system, in the governance system, in the regulatory system, that you would say permits this kind of behavior, if any?
Firstly, Madam Commissioner, I need to state that for me, honestly, this was the first. This was in June 2023. I'd been a manager in HR in Ekurhuleni since August 2003. So in that 20 years, this had never happened. It has never happened. I've never seen such overreach by a municipal manager ever before. And as much as I've had to consult, brief, and indeed take guidance and direction from municipal managers over the years, and I'm talking about close to 6 municipal managers, inclusive of this municipal manager, she has never done this before, And I don't know whether indeed she did it post this, or this was just an isolated incident, but you just get thrown because indeed the system does not envisage that such would happen. You do not have anything in the system that provides you as I can say divisional heads, part of, let's say, senior management with HODs and the municipal manager being top management, so be senior management. But you don't have anything that actually provides for this, because this was unique. This was unique, honestly. Besides submitting a grievance, which, yes, indeed, was open to me as an official, but beyond that, there's nothing really to do that could have been done.
So it's not...
The system was not actually designed to anticipate this type of overreach.
Am I correct to understand you to be saying it's not so much a shortcoming of the system and the regulatory governance tools that are in place? It is more a personal, it's more a personal thing, the person and whatever informed their conduct. Am I correct to summarize you that way?
That's on point.
Thank you.
Thank you, Commissioner. Mr. Nciza, perhaps then to locate the totality of your evidence under this heading thus far, you've explained to the Commission that Brigadier Mkhwanazi was suspended in February of 2023, correct?
Yes.
And that suspension was uplifted after intervention from Ms. Xolani and the city manager. Is that correct?
I think it should be the other way around. After intervention by Mashazi.
There we go. The of the brigadier's suspension and his resumption of duty in May of 2023, Chief Mapieye made an attempt to move him out of his ordinary station. Is that correct?
Yes.
And that attempt to keep him out of his ordinary station in order to protect the integrity of the investigation was also blocked through intervention.
Yes.
The intervention of who?
Well, the letter came from Xolani, but I believe that it was per instruction by Mashazi.
Thank you. And you've now testified that in June of 2023, an attempt was made to serve the charge sheet upon the then Brigadier Mkhwanazi, and that the service of that charge sheet was blocked. Is that correct?
Yes.
And please remind the Commission at whose intervention that blockage was alleged to have occurred.
Mashazi and Xolani. Quite honestly, my sense is that it's Mashazi instruction to Xolani.
Okay.
But at the center of it would have been Mashazi, and Xolani just follows, because she's afraid of being shouted at.
Thank you, Mr. Nciza. If I could then ask you to turn to paragraph 68 of your witness statement, please. 68, we're now on page 23.
Yes.
Yes, you've indicated the blockage of serving the charge sheet. Please then tell the Commission what steps you took immediately thereafter.
Well, I called Mapieye after I'd instructed Sizamba to also record this blockage on email. I also called Mapieye, indicated that this is the situation, that the charge sheet has not been served. He also just took note and said, it's fine, let's see what we can do.
Please continue with reference to paragraph 69.
And then on the next day, Chief Mapieye then called me. Remember, we had discussed the issue on the previous day. Then the next day he called me to say that he was called by Mashazi to her office and instructed to bring the docket. Then, when he got there, he was told that he must go and see Advocate Kemi Behari, who was the head of corporate legal services. And then when he had an engagement with Kemi, gave Kemi the docket, perused it, and then he took a view that there was no case against Mkhwanazi. I must also pause to note that indeed the docket did not have the charge sheet that was perused. The docket that was perused was the investigation report with its annexures, but it did not have the charge sheet from the lawyers at that time.
But the documents, the investigation report would have told him.
Yes, the merits.
Both the city manager, if she wanted to read it, but Advocate Behari, who is given the docket, the report would have told him what are the allegations.
Exactly.
Thank you.
So it cannot be an answer to say Advocate Behari did not have the charge sheet, because if you want to know whether or not there's a case against Brigadier Mkhwanazi, you asked for the charge sheet. You can't say because it's not there, I'm going to form a view that there is no case.
Well, that is what is expected of a reasonable process. I'm not going to say a reasonable person. A reasonable process would dictate that indeed you must have the fullness of the situation in order for you to make an informed decision. You know, I honestly don't understand how this transpired, because you have a situation where the previous day a charge sheet is blocked from being served. So for all intents and purposes, they knew that the charge sheet was there. There is a charge sheet. But for some reason, when there's an engagement with my PA, the engagement is limited to an investigation report, you know, and the concentration is to say that this investigation report does not have evidentiary material that to sustain the holding of a disciplinary tribunal. And I can tell you now, commissioners, this is discipline management. This is not a trial in court. You know, this is about discipline. You know, quite honestly, we have approved disciplinary cases on far less than what is contained in that bundle, you know, or in that docket, because this is about affording an opportunity to an employee to come and explain himself to the employer about his conduct or his alleged conduct, you know. So the test is not as strenuous. But nonetheless, you have a situation here where a decision is taken to say, no. There is no case here. There is no case here. And this version or this thing that is given to my PA gets given to me at a later stage as well.
Did Advocate Bihari speak to you or to anyone from your section who have been involved with this matter when he considered the docket and he got to the conclusion that there is no case? Was there ever any engagement?
Not at this stage.
Not at this stage. And before this, had he been involved with you or anyone in your department relating to this matter?
No. Before
this point?
Before the 21st of June, there has never been a Advocate Kemi Behari, anywhere in the picture, especially on this matter. You know, when I had a conversation with Chief Mapia, you know, I was quite taken aback to say, but who can a guy? You know, where does he come in? You know, the delegations matrix at that point did not even involve him whatsoever. There was nothing that actually spoke to litigation. At this point, there is not even litigation. This is a disciplinary hearing. That's all. So there was no need for me to have a discussion with Advocate Behari. And for that matter, there was not even a need for me to have a discussion with Tashega or Mashaz. There was simply no need.
And before this intervention, or now the involvement of Advocate Bihari as, I think, head of legal, the legal person,
yes.
Had the legal department gotten ever involved in disciplinary, other than litigating, when it's now at litigation, but at the stage at which the employee relations department is managing disciplinary processes internally? Is there a role for the legal department?
The legal department would get involved in discipline management matters that are at the senior management level. The disciplinary regulations, the heads of departments, they got involved. You know, I know that Advocate Kemi Behari was involved at some point when we were dealing with the COO. At some point, we were dealing with an HOD. He got involved with those particular matters. You know, even then got involved because of his deployment by the city manager. But in the actual discipline management matrix, there was no need at that point for the legal department. There's a number of cases, even at HOD level, that had been processed. Advocate Behari was HOD corporate legal services from the 1st of March 2023. So historically, you would not have the involvement of the corporate legal services department unless there is a particular legal issue that requires their involvement, but only at that level.
And Brigadier Mkhwanazi's position was not that senior management level you are speaking to?
No, it wasn't.
Thank you. Thank you, Ms. Mkhwanazi.
Thank you, Commissioner. Mr. Nciza, you say at the end of paragraph 69 of your statement, you say there that Chief Mapieye was subsequently instructed to withdraw the internal investigation into Brigadier Mkhwanazi. In the following paragraph, you discuss the effect of that withdrawal. And please detail that to the Commission.
Yes, Commissioners, the so-called withdrawal letter of the 22nd of June 2023, firstly, Mapieye was functus officio. His role ends at a particular point. His authority ends at a particular point. And that point is reflected in his letter that I approved on the 12th of April 2023. Beyond that, he has no authority over the matter. I am seized with the matter. So the letter of the 22nd of June was intended to undo something that had already, transpired. In essence, firstly, the letter says he's withdrawing an internal investigation because there was no withdrawal of that particular instruction that they should prosecute the matter as it stood.
You are more asked the question because of your experience in the space as an employee relations person. Is it not a form of misconduct to intervene in this way without a rational basis for it?
It is. Straight up, it is.
And you would say, where does it belong in your code? Either in your code of discipline, which lists forms of misconduct, or as a matter of common law or law of general application? I ask because it bothers one that you would have this kind of conduct, which is highly suspect, if one, at best. It's highly suspect, and yet there's no consequence for it. And it has serious implications because it has someone who is accused of serious misconduct, very serious misconduct, who goes unpunished because those who have power by virtue of office, they use it to circumvent lawful processes. They're basically the law, collective agreement. It's a form of subordinate legislation, and they subvert the law for no rational basis. Surely it can be, that's the end of it, and there's no consequence for such people.
You are correct, Madam Commissioner. It can be the end of it, and it shouldn't be the end of it. And perhaps critical in your analysis is the abuse of power by people that are in authority. This is a a classical demonstration of such. You have people that are in authority, they step in and they cause something like this to happen. But not only did they cause something like this to happen, other things flowed from it. Flowed from it. You have a person who was supposed to be disciplined and potentially be dismissed in June. In December, that person gets promoted. By who? By the very same people that stopped the discipline. The very same people that stopped the discipline. There's another issue that I'll be raising later on in terms of the effect of the stoppage. And you could see that indeed what was at play here is a serious, and as by deviation would be
a mild way.
It's yeah, to say that there was a deviation from processes and procedures would be, yeah, I know it's kindergarten language, and I can't find the right language to actually describe
greatest disregard of blah blah blah.
Blatant abuse of power in disregard of the law.
If the evidence leader would allow me,
You have the chairperson's permission to speak freely.
Really, okay. You have a situation here to show. I just want to show how this thing actually played out. The disciplinary charges stopped on the 20th of June. 2 weeks down the line, a report gets served that seeks to give Advocate Kemi Behari and Linda Tlashega a 600,000 rand increase. And that report does not provide any basis why such increases must be effected. These two people are appointed on the 1st of March 2023. They are still under probation. 4 months after their appointments, a report gets generated seeking to provide them with massive increases. And nothing has actually happened in the intervening period between March and July in terms of municipal processes. What is in that report speaks exactly to what they had in March, but in July, that is used to say these people must get these massive increases. I can only suggest or opine, but thank you. You are aligning yourselves to the instruction. You've aligned yourselves to the instruction. You've aligned yourselves to what I want as the city manager. My person is not to be touched, and you've ensured that my person is not touched. Here is an increase.
Unless, of course, there's evidence that on their appointment, the terms of their appointment was that at the end of the probation period, they would get increases. Yeah. I'm not saying that's what happened. I'm saying maybe it is somewhere.
There is no such. Doesn't exist in local government.
You are the expert. I will not.
There is a regulatory framework that deals with what is called the upper limits for the total remuneration packages of municipal managers and managers directly accountable to municipal managers. That thing is determined by the Minister of Cocta. There is a framework on how such salaries are to be determined, how even cost of living adjustments are to be effected. But for the first time in the municipality, again, immediately after having protected Mkwanazi, increases were effected. So for me, it's yeah.
I'm going to test your opinion or your view again. You see, Parliament will say to people like you, we've done our job, we've passed the Protected Disclosures Act. Everything you've just said now, you could have made a protected disclosure and you would be protected from an occupational detriment. And the law is there for officials like you to use it. Why did you not use it?
I was suspended in September and dismissed the next year without even a hearing.
2 months later.
Yes,
But you accept that the law is
the
there.
law is there.
And
I've utilized the law.
at
I've
any
dealt with the
stage-
issues that pertain to that law.
between May and August, a protected disclosure could have been made.
I take the point.
Thank you.
Well, maybe let me add, and it's on the back of that you could have taken steps. On a quick look, the abuse of entrusted power is defined as corruption. So you could have gone to the police if with these things that don't make sense to you for the police to investigate. So there may have been an avenue that was not explored. Okay.
Well, there's things that I suffered, commissioners.
Yes.
There's things that I've suffered personally, even during the period that we are talking about. You know, there's things that I suffered.
Thank you. It's please do not understand us to trivialize the circumstances that you found yourself, not just you, in fact, even the witnesses that preceded you, to trivialize them and to be criticizing that you didn't do anything. It is simply to explore whether you realize or recognize that there may have been things that you could have done, but you didn't do because of the circumstances.
I think that we will perhaps, in the fullness of my testimony, then perhaps also revert back to an analysis of what could have been done, or, you know, what did I miss out, so that indeed if commissioners were to get a full sense of the circumstances that one was confronted with, then there will be a better appreciation of some lack or in terms of processes that one could have been able to put in place.
And remember, we have the benefit of hindsight, which is unfair to you, but
Yeah.
take it in that spirit.
Thank you, sir.
Thank you, Commissioners. Mr. Nciza, we are at paragraph 72. If I could take you back to paragraph 72 of your witness statement on page 23. In the last two remaining paragraphs of this subheading, you set out your frustrations following the inability to serve the charge sheet on Brigadier Mkhwanazi. You know, please set those out for the Commission in summary of this topic.
Thank you, Council. Of course, the legal team or the prosecution team that was appointed were very frustrated. They raised issues to say, but how can this be left unattended? I mean, remember, they had consulted with witnesses. They had even a much more fuller appreciation of what was at stake, because they not only had the documents, but they had a human view, you know, a human touch on the issues. So I engaged with the advocate that was appointed, and of course, he indicated his frustrations. I also indicated my own frustrations back to him, because the matter was scheduled to sit on the 3rd of July, in line with the 3 months that one was chasing, that within the 3 months the matter must commence. So there was that particular frustration that was expressed by all involved, let alone the frustration in the department in terms of senior management of the department. At a later date, I was updated that not only did the charge sheet not go out, but the external lawyers were also not paid. You know. Of course, this was frustrating, and indeed, we were incapable to proceed with the disciplinary hearing at all.
And can I ask you to read that last sentence of paragraph 73 into the record?
Despite engaging the most senior official at EMPD, which would be the chief of police, my superior, which would be the HODHR and the city manager, brought any inquiry into Brigadier Mkhwanazi to a halt.
Thank you. And Mr. Nciza, do you know if these charges against Brigadier Mkhwanazi were at any point ever served on him, or an attempt was made to revive or resuscitate this process? I ask the question mindful of the fact that you left in March 2024. At that point of departure, were you ever aware of an attempt to revive or to attempt to reserve the charges on the brigadier?
I need to correct the point about when did I leave. I was suspended effectively on the 7th of September, 2023, and I was rendered a persona non grata. You know, there was a directive issued that not even a single person was to speak to me from the municipality, let alone from my division. I was even actually, I even raised an issue to say, I was told that I must not even go to municipal offices even to pay for my rates and taxes. So that ordeal didn't just happen in March 2024. But coming back to your question, nothing has ever happened to Brigadier Mkhwanazi. Nothing.
That you were aware of, up to and including your point of termination?
Nothing.
Thank you.
Instead of something happening, he got promoted. Something happened. I'm wrong. Something did happen to Brigadier Mkhwanazi. He became a deputy commissioner.
Do you think your suspension had anything to do with the charges, the suspension of Mkhwanazi, the charge sheet, and all of those, or it was unrelated?
Can I hold on a bit? Let's go into the next. I need to get the fullness of what happened, Commissioner. I need to get the fullness of what happened and how these things actually unfolded.
Okay, you can stop me as well if it belongs in what you're going to be saying later, but I'm asking the question on the back of what the last thing you said, which is instead he got promoted. Now, we've had evidence, I think from Chief Mapie, about an interview, a selection process, application, shortlisting, and something else that ended up prematurely without that ended prematurely because a step that was supposed to complete that process was not done, but the next thing he was appointed and he got his colors. Do you know anything of, I struggle to remember the name of that thing.
His rank.
His rank. But didn't learn to wear it properly. Were you involved with that selection process? Do you know anything about it?
Madam Commissioner, I was not involved with the selection process, but I do know about it. And again, this is another demonstration of how disregard, to use the chairperson's language, disregard for policies and procedures has been a norm of late in the municipality. Firstly, and this is from my understanding in terms of even my engagements, even post my suspension, because even though there was this directive, I do get engaged by people on a number of things. The selection panel that was used, I would criticize it. This was a position of a divisional head level, very senior in the police environment, which is a very specialized environment, specialized in its functionality, specialized in its regulation. Then you have a selection panel where it is the chief of police, of course, who's an expert in policing. It is the HODHR, who knows nothing about policing, with all due respect to herself. It is the HOD, Sports, Recreation, Arts and Culture. Nothing about policing. Now, the problem with how recruitment and selection happens in our environment, and this is a criticism that I even actually made in a matter where we were a respondent in an unfair labor practice dispute relating to promotion. And the criticism that I made, unfortunately for the municipality, we won using that criticism, is that we have a situation where the actual suitability of a candidate for appointment is premised on an aggregation of the scores. You aggregate the scores of the three panelists. And then, having aggregated the scores of the three panelists, the candidate that has got the highest score gets to be the one that is recommended. Now, in a situation like this one, the two people that are not experts on policing, I have not seen the scores, but I can tell you now, would have scored Mkwanazi better than the person who's an expert on policing, because there's a predetermined notion that he will be promoted, come hell or high water. That is the first point of call, before even getting to the other steps, how this thing was structured. It had a predetermined outcome. So whatever the chief of police scores should not be used as a benchmark of how the person is answered. If the chief of police scores the candidate 2 and the other panelists score the candidate 4, aggregate the scores, that candidate becomes the highest scored person, even though the expert said these answers are not correct.
Is that a fair criticism, though? What options were there within the municipality to constitute the panel differently, taking into account what you're saying about experience, that the people who know anything about the environment should not have been there? I think that's a nub of what you're saying, that you've got two people who know nothing about policing. Okay. What would have been the options available to the person constituting that panel, apart from the chief, who is an obvious choice? What options would there have been for the other two?
The options that would be for the other two are informed by what has happened with previous appointments at that level in the EMPD. All right? Because this was not the first time that the EMPD was having an appointment of a deputy chief of police. It was not the first time. So in previous instances, you would have the chief of police and the head of department disaster and emergency management services. The head of department disaster and emergency management services is the closest, because that person is involved in the uniformed service. In the uniform service, and indeed there are those overlapping functions that actually are involving both EMPD and DEMS. We call them DEMS, the Disaster and Emergency Management Services. So the precedent in the municipality has always been that DAMS HOD, even if it's an acting HOD of DAMS, would sit with the chief of police.
Correct?
That has been the precedent.
Okay.
But I can tell you now, there's been a number of instances where when you're having a divisional head position, specific individuals are then drawn to be the panel because a particular outcome will then be determined. Specific individuals that are consistent in the panels for divisional head positions.
I interrupted you. You were still explaining what you know about that process that ended prematurely, the selection process, but somehow Brigadier Mkhwanazi was selected.
Thank you, Madam Commissioner.
Please hold that thought. Let me continue the interruption. On the facts that you are aware of, why do you think the city manager was as invested as she was in Brigadier Mkhwanazi? I wanted to also include Ms. Tasheka, but I'm not sure whether I should, because at some stage you said that she didn't want to be shouted at and wanted to see the finalization of the DC process without a hearing having taken place. So maybe let me leave her out of the equation for a moment. So why do you think, on the facts that you know, the city manager was as invested as she was in Brigadier Mkhwanazi?
Thank you, Chair. I think, Chair, there's a point, I think it was I'm not sure it was yesterday or early this morning, when I had to give a view on the proximity claim. And I indicated that when you look at the hierarchical arrangement of the municipality, there shouldn't be a proximity between the two individuals. But nonetheless, that proximity does exist, and perhaps one would have to then investigate what informs this proximity. Because this proximity, in my view, is what then informs the municipal manager's attitude, the municipal manager's conduct when this individual is involved. When this specific individual is involved, there's a number of matters that we've dealt with this municipal manager. A number of matters, including HODs, including other people that were even in her office, directly in her office. But this was unprecedented. And the only thing that one can opine is that it is unprecedented, and it is the type of conduct is informed by things that are extra. Is there extra organizational? There's extramural activities. So there's something that is beyond organizational arrangements that, in my view, exist between Mashazi and Mkhwanazi. That would then inform the proximity claim. That would then inform the conduct of the municipal manager in respect of this individual, protecting the individual, not only protecting the individual, advancing the individual. There's so many things. You have a situation where, and it's just unheard of in the municipal environment. A person gets appointed to a position that is the equivalent of other positions, and there are other people that are occupying those positions. This one comes now. Umafigizolo. Literally, this is the Mafigizolo. But then the Mafigizolo gets to act and be the supervisor of the people that have got more service, more experience, more qualifications, more this, more that. But this person gets to act. And these ones never get to act at all. For as long as Chief Mapie was on leave, was put on special leave, was suspended, one person acted. Council policy on acting is clear. There must be a rotation of acting. But there's no rotation of acting. This person gets favored above everybody else. And there is no rational basis in terms of the institution, in terms of processes of the institution that I can think of that would put the municipal manager in that position where she has to make sure that this one person enjoys protection, enjoys benefits, enjoys everything. There is nothing institutionally. So then it has to be on a personal level. The allegation against me and Chief Mapia is that we are personal against Julius. I don't know how do I become personal chair. I don't even know the man. I've never seen him outside of uniform. I've never seen him outside of uniform. I've never even met him at a funeral, except for a funeral of an EMPD official, where even then he's in uniform. But I'm personal against him. I don't even know his stays. I don't even know his family. I know nothing about him, except for the fact that he's an employee of the municipality. You know,
Based
but
on
here clearly there is some personal relationship.
Based on what you know, would you say that Ms. Tsasheka's claim that she did not want to be subjected to continued rebuke was the full answer to how she herself conducted herself with regard to Brigadier Mpanazi?
My understanding of Ms. Tsasheka and her tenure as the head of department HR, which would have commenced when her predecessor left the institution, I think it was at the end of July 2022, and then Ms. Tsasheka was appointed to act in the position from August 2022 until the 28th of February. She was acting, and then she got appointed from the 1st of March. There is no other rational basis that I can think of that would make her as an HODHR, you know, to act in the manner in which she acted, except for her fear of marshals. Because that is how she has always addressed herself.
That's exactly what I want you to address. On the basis of what you know, do you think that the manner in which she acted was indeed motivated by her fear for Ms. Mashazi?
Nothing else.
Thank you.
Thank you, Chair. It's 4:01.
Let us adjourn and resume at 9:30 tomorrow.
Emapili muna, bathi selilo tsaka.